let me be absolutely clear, this is Bruin compliant. It is designed to comply with the Supreme Court's dictates and direction when it comes to concealed carry weapon regimes.
Well, apparently not, because that's right. We got the injunction on our challenge to the sensitive places on SB 2. Let's talk about it. Hey everybody, welcome back to the channel today. That's right, Senate Bill 2, or at least part of it, has been knocked down in the federal district court. We got a preliminary injunction on the lawsuit May v. Bonta, which was our challenge to the sensitive places portion of Senate Bill 2. Here to talk about it today, we have a couple of associates from Michelle & Associates, Costas Moros, the attorney who wrote the lawsuit, and Alex Frank, the attorney who argued the lawsuit yesterday for 3 hours with Judge Carney in that hearing. Guys, how are you today?
Great, Kevin. Thanks for having me on again.
Hi, Kevin. Good to see you again.
Absolutely. But before we get into that today, guys, please be sure and like, share, and subscribe to these videos. These are laws and lawsuits that are directly affecting you, specifically with Senate Bill 2 on January 1st, 2024. We need to use these algorithms to get this information out to as many people as possible, not just for that January 1st deadline, but also for the elections coming up, to draw some accountability to some of these legislators that are putting these laws in front of us for the 2024 election. So, Costas, my first question is for you. If you can, really quick, just give us a brief rundown of Senate Bill 2 in its entirety, and can you also explain the specific challenge that CRPA brought with this May v. Bonta lawsuit?
Sure. So Senate Bill 2 completely changes how carry works in California. It was passed in response, of course, to the Bruin decision. It was passed to undermine the Bruin decision by no uncertain terms. So it both drastically changes how permits are issued, but in respect to this lawsuit, it also makes carry presumptively banned basically everywhere. You can't carry in restaurants unless they post sign, any business open to the public unless it posted sign. You can't carry in parks, libraries, bars, playgrounds, churches, etc. Just anything you can think of that's a relevant place that people go to, including the wilderness of a state park, is off limits under SB 2. And that's why we sued to stop it, frankly, because it was going to make, even as it made getting a carry permit harder, it also made getting a carry permit pointless, because all that was really left in terms of the supposed right to carry, as Gavin Newsom mocked, was streets and sidewalks. And by the way, streets and sidewalks only if you're not actually going anywhere, if you're just walking aimlessly, I guess, for exercise, because everywhere you'd go to was restricted. Even some businesses that would post a sign, let's say you had a business brave enough to post a sign in Los Angeles saying carry is allowed, if they shared a parking lot with a bar or a bank, can't carry there, because the SB 2 also blocks the parking areas of most of the sensitive places it lists. So it was it's a very nefarious law meant to kill the right to carry in the cradle, and that's why we're glad we stopped it today, as we're about to discuss.
Well, having said that, Alex, when Judge Carney sat down in that courtroom, the first thing that he did was ask you and the other attorneys making statements yesterday to answer 4 or 5 questions. A couple of them really stuck out to me that made me feel like, okay, this judge is on the right track here with this. The first one being, does it seem like the legislature actually considered the Bruin decision in this case? The second being, why is it that you would want to target CCW holders specifically when they're not the ones that are actually committing all of these laws that you're saying we need to be safe, or these, I'm sorry, not committing these laws, but committing these crimes that you're saying we need to be safe from? Then you go through a 3-hour hearing, and then less than an hour after that hearing breaks, a 43-page decision comes out. I'm just kind of curious, as far as the process of the court is concerned, is that normal? Were you expecting this order to come so quickly after the hearing?
I had a hunch that we might get a ruling quickly, but not that quickly. No. The law was set to take place on January 1st. And given that the hearing was on, the 20th, I was optimistic that we would get a ruling quickly, and this is not my first rodeo now. So whenever there's an injunction that comes down, there's a mad dash to the Ninth Circuit to address the issue of a stay. Usually the trial court will put a stay in place for a short amount of time, but it has an expiration date, which means the DOJ has to go to the Ninth Circuit to continue the stay pending appeal. And I thought, well, I don't think he's the kind of guy that's gonna, try to, create a whole, storm of work for the DOJ on the, over the holiday season. And so I thought, maybe he'll do it just after the holiday season. I can only speculate, but I had no idea we were going to get an order, within minutes of the hearing concluding. That was shocking. And when he took the bench, he said, I have a few questions, and I don't want to hear extensive argument on any of the particular subdivisions of the statute, because there's over 25 of them. And I thought, I thought he probably wouldn't want that, because he scheduled the hearing for the afternoon, and there's two consolidated cases, there's a lot of issues, and it's clear to me that one afternoon isn't enough time to discuss all these issues. And because of that, it seemed like, tilted in our favor. It seemed like he's probably made up his mind about most of these things, and he might just want to hear some thoughts from us about, what's happened in the year or so since we were last in this courtroom regarding Second Amendment law, and are there any important precedents that we should be aware of, here in the Ninth Circuit, or throughout the nation from other circuits. That's kind of what I thought he would focus on, and so that it was nice to hear him say that at the beginning. But no, I've never seen an order come down that quickly.
Well, off of first glance, the list is extensive in the order, and I'm sorry, I'm going to have to refer to my notes here. He at least at my first glance of this order, he identified the following for the right to carry in. You got hospitals and medical facilities, public transportation, places where liquor is sold for on-site consumption, public gatherings and special events, playgrounds, youth centers, parks, athletic facilities, casinos, stadiums, arenas, amusement parks, public libraries, zoos, museums, places of worship, financial institutions, privately owned businesses open for the public, and parking areas. Was this inclusive of all of CRPA's complaint? And did we win in the injunction on all of these?
I might defer to Costas on that, because I haven't read the whole ruling in detail yet, but my understanding is that we got everything we wanted. Maybe not explicitly, but if you read the whole order, I think my understanding now is that it's clear that we as far as our motion, the May plaintiffs go, I think we got everything that we wanted, but I think Costas knows the definitive answer to that question.
Yeah, I'm proud to say actually that we are the first case out of these many Bruin response law cases concerning sensitive places. We're the first one to pitch a shutout. We got everything we asked for. There's one bit of nuance with one provision pertaining to local government buildings, which is that we challenged that, but only as to parking lots, and only also as to places that are local government buildings, but are also banned by other parts of SB2, so like libraries and public transportation hubs. And the judge acknowledged that in the ruling, and basically the reason he didn't include that provision in the ruling is he was already giving us parking spaces and those other places. So I think he felt there was no need to give us the rest of the relief on subsection A5, because we had already gotten what we had expressly asked him for, and judges tend to be restrained in that sense. They're usually not going to go past the relief you explicitly asked for. So everything we asked for, we got. And in the companion case, there was a few places they challenged that we didn't, and they got it too. So this was the most complete win. We even won on playgrounds, which no other case had won on. Even judges that gave pretty good rulings, like in New York and New Jersey and Hawaii, they actually, I don't remember if Hawaii did actually, but they didn't give them playgrounds because they said they're too like schools. And what we pointed out to the court was that they're only like schools in the sense that they cater to children. The relevant similarity ends there, because you don't, drop your kids off the playground under the supervision of an adult that works there. Like there's no one there to protect them but you, and any random criminal or crazed homeless person can walk through a park in a way they're not allowed to walk through a school. So Judge Carney noticed that, and I think that's why he said, even despite these other district court rulings, I disagree, and I think you should be able to carry on playgrounds to protect your children. So we very proud of the fact that we won everywhere, essentially.
Well, I want to stick on one of those in particular, because technically speaking, if somebody puts a sign in their business window stating that you can carry, technically you would be able to legally carry in that store. So I'm curious on the privately owned business open to the public. This is what Judge Carney, Jacob, if you can bring this up from the actual order. Stated on this matter. He stated, although private property owners have a right to forbid, conceal carry on their property, the state may not unilaterally exercise that right and thereby interfere with the Second Amendment rights of law-abiding citizens who seek to carry for self-defense outside their homes. Kostas, in a past video, you discussed this as the vampire clause, if I remember correctly, which would force business owners to actually put a sign up saying firearms are welcome here, as opposed to the inverse. Was this part of this injunction as well?
Absolutely. I mean, the vampire rule is the only provision that's been enjoined by literally every court it's been in. There's been 5 or 6 district courts, and now even the Second Circuit, which, by the way, was an otherwise terrible ruling, a panel that was very hostile to the Second Amendment. Even that panel in New York struck down the vampire rule. So it's not surprising to me that we won on that. In fact, I was a little amazed that the state spent so much time in its argument yesterday trying to defend that piece of garbage. Like they knew how it was going to go. So yeah, this order definitely includes that, and we're pleased it does.
Alex, going back to the hearing, something else that really struck me, Judge Carney was going back and forth with the state's attorney on public transportation. Something that he kept going over and over again was, don't people have the right to defend themselves? I mean, what he was talking about was his personal experiences taking public transportation. I think he mentioned buses and trains, both in LA County and in Orange County. He said that he, doesn't even necessarily feel safe all the time. Isn't it important for people to be able to defend themselves? He even drew in his order a line towards discrimination. Jacob, if you could pull this one up, he states in his order, the prohibition even extends to public transportation, imposing discriminatory impacts on people of lesser means and harming the environment. I'm kind of curious on your take on, his argument there. And also I'm sort of curious of your opinion. Who exactly are we arguing with here? Because of all the times that Judge Carney asked that question, the state's attorney not once even made a mention, with or without firearms, that people had a right to defend themselves. So I'm sort of curious on your opinion on that.
Absolutely. I was very pleased to see Carney say that. I rode the LA Metro subway system for nearly every day for 3 years when I was in law school, and it was fantastic, and it was clean, and it felt safe enough, and saved a lot of time. And I recently rode it, and I could not believe what my eyes were showing me. It was not safe. There were people, homeless people, drug addicts everywhere. And my understanding is that crime has been a big problem, and more dead bodies have been found on the LA Metro in the last year than ever. People overdosing on drugs. It's not the kind of place that you would want to spend any time in. And to see that he was aware of that, and that he understood that, that somebody who wants to who uses public transportation because it's the most economical way for them to get from point A to point B, denying them that right to protect themselves in this squalid environment that used to be nice and isn't anymore, it bears disproportionately on people of lesser means who maybe can't afford a vehicle, so they can get around. To see him understand that and grasp that and relate to it, and talk about, I've been on public transportation and not felt safe, and then to combine that with the more kind of moral driven question to the Attorney General of, is there a right to self-defense, or is there not? And to see the Attorney General dance around that and give him, legalistic mealy-mouthed responses to that question, to me, it really proved what Carney understood and what we argued, which is that this law isn't about safety. It's about nullifying the right to carry outside the home. That's the purpose of this law. Newsom barely concealed that, which was another question that Carney asked us. Do we think this is in good faith, or do we think this is a product of animosity for the Second Amendment, for the right to self-defense? And it's evident that it is.
Shall provide this right.
And to see him, ask that of the Attorney General a couple times at the hearing was great. It showed that he really wanted an honest answer, and he didn't get one.
Well, you mentioned that they're kind of trying to dance around some of these questions legally. We've had several videos with Chuck Michel where he's basically discussing that because of Bruin, the same way that they did with Heller, they're going to try and pack as much weird, fake, whatever kind of analog into these lawsuits as they can. I'm curious, did we see a lot of that here? I know that Judge Carney did mention that, on at least a couple of things, the list of lawsuits, or laws rather, trying to fill the analog for arguments in some of these things wasn't exactly extensive. How big of a stretch were a lot of these pieces of evidence, as it were, that they're trying to justify this law with?
The stretches were big, very big. We all know what an analogy means, right? We all have a common sense understanding of what an analogy is. And the Deputy Attorney General does not. They made some fairly ridiculous arguments. There's some language in the key cases, right? The Heller case, the Supreme Court case from 2008, and the Bruin case from 2022, about these presumptively sensitive places. And those presumptively sensitive places are schools and government buildings and polling places. And so, that's the reference point that the Attorney General has to basically try to analogize anything that they want to be a sensitive place to. So if you look at the example of banks, like they argued that banks were akin to airports. In what sense are they at all akin to airports? And I pointed that out to Judge Carney. I think they tried to make the argument that because vulnerable people sometimes are at banks, well, that's how they're similar to schools, because vulnerable people are also at schools. These arguments just fly in the face of common sense, and Judge Carney did not buy them. And it's not. It would have, I think, helped the Attorney General a lot more if they had scaled back the scale of their defense of what they were trying to defend and uphold, and just focused on maybe a few important things, and tried to make more nuanced arguments and argue for the application of an analogical standard that has some firmer principles behind it. But they were grasping at straws. They were stretching to try to make everything fit into these presumptively these limited categories of presumptively sensitive places, and luckily the court did not buy it.
Well, I guess hopefully we will continue to see judges actually see through that and continue to get good decisions like these. They certainly have the framework to do it through Bruin. Kostas, I kind of have a community question here. There have been some rumors, I've been getting some calls of perhaps there being implications on the emergency regulations passed down that are connected to Senate Bill 2 being affected by this order here. Having read through it, I'm curious, what are your thoughts? Is there any effect on those regulations from this order?
There is no direct effect. This order pertains to the designation of sensitive places in SB2. It does not pertain at all to permit issuance. That said, the only thing I could think of is if the DOJ at all starts to get a little gun shy. That's never been like, pardon the pun, that's never been like them before. They usually don't care what courts rule and they continue enforcing gun laws, passing new ones. But we'll see. But that said, I think our other lawsuit, CRPA versus LASD, which we've just started, now we'll turn our attention to, that one may actually be more of a chilling effect or what have you to DOJ, because it directly pertains to permit issuance and the delays in Los Angeles around permit issuance. And I believe we were submitting or will submit a comment letter regarding the proposed DOJ regulations. And I know they haven't actually officially posted them for comment yet, which is a bit strange because we were expecting that to have happened already. So hopefully they're reconsidering. I know there's rumors that they are, but I haven't been able to confirm those. So hopefully they reconsider and don't go forward with those regulations, because it'll slow down CCW issuance even further, because there will be very few people who are allowed to teach CCW courses. And of course, SB2 moves the requirement from 8 hours to 16 hours, so you need them more than ever, but there will be less of them than ever.
Well, I guess, I guess, that's something that we're going to continue and follow along with and look forward to striking down in the future. But for now, we can rest assured, if you have a CCW, all of these places that they created as sensitive places in SB2, law enforcement is not going to be able to enforce that CCW holders cannot go there with their firearms to protect themselves. This is great news. This is a huge victory. Honestly, guys, it feels pretty similar to me in 2016 when we got that preliminary injunction for Duncan just a couple of days before the law was going to come into effect, saying that it was illegal to own 10-round magazines. What are we looking forward to? What are your final thoughts on this lawsuit for the community going on through January 1st and for the litigation process going forward?
Well, first things first, we know Attorney General Bonta and Gavin Newsom are already crying about this on social media. They're misleading the public. I know they've both put out statements essentially implying that this ruling will now allow guns in playgrounds and parks, but what they leave out is we're just preserving the status quo with this ruling. This has always been legal in California, and they're misleading the public into thinking this is some new change when it isn't. And we know they're going to run crying to the Ninth Circuit to ask for a stay. And we'll see it's going to be a little bit of the luck of the draw on the Ninth Circuit. It depends what panel we get. But we do have a couple things in our favor here. One of those is, unlike some of our other cases, we are merely preserving the status quo here. That's all we want, is to keep the current status quo in place. And also, Hawaii asked for a similar injunction on their very similar ruling back in August, and the Ninth Circuit did not state at the time because they were going to wait for the district court to rule, but the district court never ruled and Hawaii never followed up. So Hawaii's injunction has been in place this whole time. So it wouldn't really be fair of the Ninth Circuit to make us lose our injunction while people in Hawaii continue to have theirs, and I'm glad they do, but we should as well. And we're going to, when the state inevitably tries to stay this with the Ninth Circuit, we're going to be sure to point that out.
So for the immediate future of this case, we will be at the Ninth Circuit on appeal, and there's going to be a decision on whether the injunction is going to stay in place or whether it will be stayed. And as Kostas pointed out, it would truly be an abuse of discretion to not let the injunction take place. It would be really unfair from my perspective if, the Hawaiians, in addition to the weather, they also get to keep their Second Amendment rights, but, Californians don't. What panel we get at the Ninth Circuit will likely be determinative of that, and may warrant, if we don't get the result we want, it might warrant going to the Supreme Court. Although, given the motion for preliminary injunction posture, that could change the calculus there. But the good news is that we were successful, and the counterpart lawsuit, the Carolero case, was also successful. So between the two of us, we were really fortunate to get as much of this terrible law enjoined as we did. We're pretty optimistic about what's going to unfold, and we'll proceed to adjudicating this on the merits probably sometime in 2024.
Well, I got to say, guys, this is a great victory for CRPA in California as a whole. I want to thank you guys very, very much. It was great work. It was masterfully done, both on both of your parts, and Californians all over the state are definitely going to benefit for this. I want to thank you guys again for also being with us today. I appreciate it.
Good speaking with you. Thanks for having me on.
Yeah, thanks, Kevin. It's always a pleasure.
Absolutely. And we are going to continue and follow along as this litigation progresses through the Ninth Circuit and maybe even further than that. We're going to continue fighting. And guys, if you like these videos, if you like this content, and if you like these results, please be sure to like, share, and subscribe to this channel. Look in the description below. If you're not a CRPA member, you can contribute to these lawsuits for Californian Second Amendment rights by becoming a member down there today. Also, hit that notification bell so that you get notified as these videos come out. As you can tell, they come out in real time as the decisions are made and as the lawsuits are filed. As always, guys, thank you very much, and we'll see you on the next one.